Members, this is the appointed time. We have a quorum. Let me invite the administration to come in.
好，咁啊，我簡單讀一下咧，今日
Let me read out the attendance list. As the government officials are coming in, we're joined by Ms. Doris Ho, Permanent Secretary for Development, Ms. Eleanor Chan, Deputy Secretary for Development, Ms. Joyce Tam, Land Registrar, Mr. Eric Lee, Deputy Principal Solicitor of Land Registry, Ms. Joyce Wong, Assistant Principal Solicitor, and also Mr. Wesley Look, Senior Solicitor from the Land Registry. We also have 3 representatives from the Department of Justice, Ms. Francois Lam, Mr. Edison Chan, and Ms. Eunice Wong. So back to the agenda. The administration has provided a response to the issues raised at the meeting on the 19th of May 2025. That's CB bracket 1993/2025-01. And the O2 is a response paper. The Law Society has also made a written submission to the Bills Committee. I understand that the administration has also received a copy. But perhaps you can give us, whilst preparing the written reply, a verbal reply very succinctly, because members have shown concern about the definition of terms. Mr. Andrew Lam, would you like to begin? The Law Society's submission refers to definitions of terms. I appreciate that the administration would need time to give a written reply, and we are now at the clause-by-clause scrutiny stage. So these definitions will be of relevance. Perhaps the administration can give a verbal reply at this moment. True, you are preparing a written reply to the Law Society submission. I understand. You can submit that later. But in relation to administrative arrangements, if possible, please give a give a verbal response now. Chairman, subject to members' support, may I suggest that the recommendations or suggestions in the Law Society's written submission be handled this way. As you mentioned, we received a copy. We also read the proposed definitions for different terms. But what's more important is the questions. And that is to say, after introducing the title registration mechanism in the future, the Law Society asked about the difference between the conveyancing procedures under the new system and the current system. Now, Chairman, we are preparing a written response and would like to provide a comprehensive written reply to the Bills Committee before the next meeting to facilitate the discussion. So my suggestion is this. We will resume the clause-by-clause scrutiny very soon. So when we come to the relevant parts referred to by the Law Society, we can then give our response on these terms and see and also address the Law Society's concern. Right, I think I do agree with this approach. I will give the floor back to the administration to resume the scrutiny. Chairman, what about the response last time? Yes, very briefly. About the definition of trustee. Trustee is a common law concept. We should refer to the literal meaning and the case authorities under the common law system in determining the meaning of trustee. In general sense, it refers to a person holding a property on trust. It includes a charitable trust, family trust, and a settlement trust. However, the definition of trustee also refers to a personal representative in the case of a probate law, as well as a trustee in bankruptcy. So we need to clarify these three concepts. We set out in clause 3 that a trustee does not include a personal representative or a trustee in bankruptcy. Next point, whether short-term tenancies granted by the government will be included in the title register in the future. We will adopt the current practice, and that is no title register will be formed, especially for short-term tenancies granted by the government. Mr. Andrew Lam. Well, I note your previous reply loud and clear. In relation to new land and short-term tenancies, no entry will be made in the title register. But the Law Society submission referred to a conflict. Can you explain that? The definition of short-term tenancy only exists in the New Land First proposal. It refers to government land granted after the bill takes effect. So for new land and the short-term tenancies granted therein, it will not be recorded in the title register. Mr. Andrew Lam. So it's very clear about short-term tenancy. About long-term leases, the Law Society specifically asked about the undivided shares and that there is a conflict. Please take this opportunity to clarify the matter from the Land Registry, please. Well, for this long-term lease, so to speak, it's not a government lease. It refers to a long-term lease granted by a general property owner. So it's not related to block crown lease or government lease. It's a lease granted on a long-term basis with undivided shares on the property. So the definition is clear. Mr. Andrew Lam. Well, I read the Law Society submission. According to the submission here, there are two relevant provisions. Now, as you mentioned, in one of the provisions, there is a very clear definition, and that divided shares are not included. According to their submission, paragraph 4.4, new section bracket 26 bracket 2, is the term in English may at least involve any divided share in registered land. So I want to clarify this point. Is the Law Society mistaken? Is there any ambiguity? For a long-term lease is a way of holding the property. The property owner grants a long-term lease to another party, and then under this long-term lease, the party can then sell the individual units as undivided shares. So it's sort of an interest of this property. It's not an interest in relation to the government. So you have a piece of land held on long-term lease. It could come in the form of a single title ownership or multiple ownership. That means after the completion of a building, the individual units can be sold, and it's not a matter of divided or undivided shares. It's rather the interest held under a long-term lease. Now, let me supplement. According to the Law Society's submission, Section 2, bracket 1 refers to a long-term lease, and it actually refers to an intact portion of a piece of land. In Section 62, bracket 2, the Law Society questioned why the concept of divided shares is used. Now, our explanation is this. In terms of a long-term lease, usually it applies to a piece of land. In Section 62, bracket 2, it refers to the effect of registering the long-term lease, and we'd like to extend the effect to cover undivided shares as well, because we want to protect the certainty of land in the situation of a long-term lease being, the interest of a long-term lease being sold to individual owners. So the latter refers to the effect of registration. So just to confirm, these two provisions refer to different application scenarios. So according to your explanation, there is no conflict. It reflects the policy intent, right? So as I understand, a long-term lease means a portion of the land with undivided shares, and that at the latter provision, there is an extension of the application to cover undivided shares. The third follow-up question refers to whether the charges particulars will be recorded in the title register. The answer is in the negative. The title register records the particulars of the chargee, but not the charger or the borrower, because it's not relevant. Point number 4. Under the current deed registration system, if a charge involves more than one property, the remark PT will be included in the entry, and the same practice will be adopted in the title registration system in the future. Point number 5 about the power of the land registrar. Clause 8 empowers the registrar to exercise or act or do something to better perform its function, to exercise its power. And then the next point refers to the circumstances under which the land registrar could refuse to accept an application. About Section 8.2d, Roman numeral 7, it provides that if the provision is by and large the same as the LTO's provision, and that the land registrar may refuse the registration. D Roman numeral 7 refers to details of application, such as how the application form should be submitted, the format and the content of the application form. Now, there are several application requirements. For example, the registration should be verified in a specified manner. Now, if there is more than one new owner of the property, the application form should specify whether the property is held by joint tenancy or tenancy in common, and that their respective proportions should also be set out. These are the information required in the application form. 8.2e. According to Section 8.2e, the registrar may refuse the registration that is not completed according to the requirements. Now, this could be read with the newly proposed Section 13. So under what circumstances can the land registrar refuse to register as a certain matter? Is set out in A2D and A2E. For the former, it sets out non-compliance with the specified form or formats in the submission of application forms. The latter refers to matters that cannot be registered.
As there are already clear provisions, we don't think there will be uncertainty in the future in the amended Land Titles Ordinance. Moving on to paragraph F. In section 8(2)(c), a registered owner may verify on oath or by statutory declaration, and the registrar may require the owner to verify by statutory declaration in relation to the change in names. G. Under the current deeds registration system, the registrar may specify or amend lot numbers as necessary. This is the present administrative arrangement, and there will be a clear legal basis for the land registrar in the future under the new system. If the registrar, pursuant to the power conferred by Section 8A, specifies or amends the description of a lot number, we will, through the Property Alert Service, notify the relevant property owner recorded in the title registration record by email of the relevant amendment. Thank you. Any questions? If no, we'll proceed to clause-by-clause scrutiny. At last meeting, we were on page 28 of the marked-up copy. All right. I'll start with page 28 of the marked-up copy. Now, clause 10, amending section 9. There are textual amendments, and the details remain the same. Section 11, amending the seal of the land registry. We have carefully considered the situation in the operation of the land registry. We don't think we need to use the seal. That's why we're proposing to repeal section 12. Division 3. Registration procedures and connected matters, including the date of registration, as well as matters in connection with straddling land. Section 13 details the matters capable of being registered. These are enhancements to the existing provisions. The details remain unchanged. In C, we propose to repeal (C) (2) issued or made for the purpose of enforcing a judgment, so as long as it is in relation to a court judgment, it could be registered. Clause 13, we propose to add section 13A. That is in relation to straddling land. Let's refer to the PowerPoint slides. So what do straddling lands mean? When there is more than one piece of land, at least one piece of land is under cap 1 to 8, that is existing land, and at least there is another piece of new land registered under the Land Titles Ordinance. This means straddling land. The main restrictions are in relation to the disposal of such cases. When there are both existing land as well as new land, and when the buildings don't straddle the land. In other words, they are on the separate pieces of land, then there is no restriction and they could be registered. Moving on to the next slide. When there is a shopping mall as well as a residential building involved on a piece of land, if the building doesn't straddle either of the land in the assignment of undivided shares, there is no restriction when it is just in relation to the building of its own. However, when the building straddles two pieces of land, in this scenario, there will be restrictions in relation to the disposal of the building straddling these two pieces of land. Let's pause here, Mr. Andrew Lam. Thank you, Chairman. This is clear, but I'd like to ask about a scenario. For the original piece of land, for the access or the road use, there may be issues. So when there is a better access on the new piece of land leading to the existing land without affecting undivided shares, in this scenario, it is the same as the first slide you just now showed us. Is that correct? We are just putting restrictions on disposal. Supposing there is an access that has to do with easement. There could be mutual easement when it comes to new piece of land as well as an old piece of land. Thank you for the pictures. They offer clear explanations. Can you give us real-life examples? Well, when it comes to real-life examples in our discussion with stakeholders, they thought for a very long time and they could just come up with one example. Well, I believe there won't be a lot of these examples in the future. So if you could give us an example, we may find it easier to understand the situation. The development parameters will be clearly set out. It is rare that the land will be developed alongside other land at the same time. Mr. Louis Long. Thank you, Chairman. The example was provided by the association, REDA. I understand the administration has considered our view, and the administration will be carving out this example. Administration, yes, indeed, we will be introducing an amendment in relation to this scenario. All right, thank you. Legal advisor has something to say. I'd like to ask the administration, do straddling lands have to do with adjacent pieces of land? Well, our policy intent is to cover adjacent lands. In other words, one land touches another land. What about if we divide the lands and it become an adjacent land to another piece of land? Well, the lots could be further divided into smaller ones before they could be adjoined to other pieces of land. We could return the land and regrant it by the administration. Then it will become a piece of new land. When two pieces of land are new as well, then there is no restriction. In other words, you need to conduct some procedures. Yes, that's true. Please go on. When there are both existing land and new land, and there is a shopping mall straddling both pieces of land, there will be restrictions, and this is exactly one example. On this slide, we can see that it is similar to the first one in a sense that there are individual buildings on the existing land and on the new land. And there will be restrictions when the undivided shares are taken into account together on both pieces of land. For existing land and for new land, when we have both, what are the procedures? Then we will implement the procedure of surrender and regrant. Then all these pieces of land will become new ones. Then it won't be subject to regulation under Section 13A. We have discussed with Rita, as Mr. Lewis Long said. We have taken note of a situation. In a situation where all pieces of land are new ones, owing to technicality, say adjustments to land premiums, then surrender and regrant may have to be implemented. One piece of land will be turned into a new land. Then there will be straddling land. This will give rise to restrictions, and that is not ideal. In this situation, we will introduce an amendment and introduce a mechanism after the implementation of surrender and regrant. When certain requirements are met, we allow the new land to be turned into an existing land, and that won't affect the development of composite development. Thank you. Please go on. Marked up copy, page 32. Clause 14, application for registration. It's about the lodging and verification of applications. Subsection 2. Applications will have to be verified with in accordance with the format specified. We propose to add bracket 3, a solicitor acting in good faith and with reasonable diligence in verifying an application for the purposes of subsection 2 is not liable in damages for any loss occasioned by any inaccuracy caused by the solicitor in the verification. These are textual amendments. There aren't any changes to the contents. Marked up copy, page 33, 15. And it will replace the original 15, section 15. It details manner of registration in relation to the making of an entry, the alteration, and the removal thereof. It specifies the manner of registration. Let's pause. Ms. Maggie Chan. Thank you, Chairman. I wanted to go back to page 32 of the marked up copy. Section 14, bracket 3. A solicitor acting in good faith and with reasonable diligence in verifying an application for the purposes of subsection 2. In this regard, I'd like to ask about in good faith and with reasonable diligence. Have you drawn reference from any existing legislation in the formulation of this subsection when you mention in good faith and with reasonable diligence? Are there any authorities from which you draw reference? We've drawn reference from the phrase reasonable care. We didn't enhance the requirement in relation to solicitors. Ms. Maggie Chan, I'd like to know the origin of reasonable care that you just now mentioned.
係喺普通法
This is the standard adopted in tortious liability in the common law. Ms. Chan? Yes, I get that. I am also a solicitor. Well, but perhaps you need more time to answer my question. I want a written reply later. Please cite the case law you've considered. I think this should be made clear for the benefit of solicitors because we may have our own research and there might be different case law cited. Registrar. Chairman, let me try to answer the member's question. Well, this provision is drawn up after consulting the Law Society, and we are told that reference can be made to the Conveyancing and Property Ordinance, Section 38, and it provides that a solicitor will bear legal liability unless he acts in good faith and has done so with reasonable diligence. Now, the wording may not be exactly the same, but we have discussed and we've been engaging the Law Society for quite a long time on this provision, and I understand that a set of detailed guidelines has been promulgated and circulated among members of the Law Society. The set of guidelines contains over 40 clauses, so it provides clarity for the legal profession. It also refers to the checks that must be done during conveyancing by solicitors. Ms. Chan. Right. About the practice of the legal profession, I understand that you consulted the Law Society. But we're now scrutinizing the drafting of provisions clause by clause. So I still like to have a written reply about the ordinance you considered. You cited one, but I want to see whether you've considered others as well. I really appreciate your efforts in engaging the Law Society. Still, we'd like to have something in the public domain, and please give us a written reply to explain that. Right, please do that after the meeting. 16, clause 16. So, new 15A registration. The register is regarded to be registered on the day on which the application leading to the registration is lodged. According to Law Society, there is a question. After submitting the application, if there is a need for clarification or supplementary information, whether the date will be affected. The answer is in the negative. We will go by the date of submission of the application. Please pause here, Mr. Tony Chair. Right, my question is on the date. It seems to be important. In the English version, there are two different words used, registered and lodged. In Chinese, it's not easy to understand. It says the date is the date on which the application or the matter is registered. Can you elaborate? Say if you submit this application today, it may take 3 days or so for processing before registration takes place. So the date of registration is the date of application. It is not affected by, for example, how much time is taken by the land registry to process the registration, because the date of registration matters. Right, Chairman? But if in English it says the matter is lodged, then it means submission of the application for registration. But there is also another term, registered. So I find the Chinese rendition difficult to understand. Can we double check the Chinese drafting? Well, in fact, it's regarded to have registered on the day on which the application leading to the registration of the matter is lodged. Maybe I'll give the floor to the Department of Justice. Thank you, Chair. This provision should be read along with the interpretation clause that is about the date of lodging the application and the date of registration. The effect of 15A is about the day of registration. And then in Chinese, it provides, after the colon, deemed or regarded to have been registered on the day on which the application is lodged. And that means the application leads to the registration of the matter. Well, this is a rather complicated concept. Inevitably, it is also so drafted. We believe this provision can reflect the meaning of our meaning. Any further question from Mr. Tony Chen? No? Mr. Andrew Lam? The mic is not on. Well, I'd like to reframe this question as a point of confirmation. According to Section 15A, it's actually the same as the date of first registration in 22, in essence, unless there is any exception, Mr. Lee. There shouldn't be any exception unless we refused the application for registration and the applicant submits something else to apply for registration again. Mr. Michael Lee. Right, my question has been answered. My question is whether the date of first registration is regarded as the date of registration or not. The registrar? Did you ask whether the registration go through or not? Because it says here, regarded to have been lodged, say you lodge the application on the 1st of June, it takes 2 weeks to process the application, and yet the date of registration is regarded to be the 1st of June. So that means either you successfully apply for the registration, which happened on the 1st of June, or you don't get any registration. Right, clear. Ms. Maggie Chan. A follow-up question. Now, if there is an error in my application, the current practice is to stop the deed, and then if the error is not rectified within a year or two, and then say 2 years later I lodged the application again, then how should the registration date be considered? Well, we have requirements for the application to be submitted again within the time frame, and if the requirement is not met, then the application will be rejected. What about the date? Is it provided in the subsequent provisions? Registrar. If we go to Section 8, Functions and Powers of Registrar, D Roman numeral 5, it says the applicant fails to take any step required by the registrar in relation to the application within the period specified by the registrar, then the registrar is empowered not to process this application further. Right, I think you should explain that to the public, because we don't know whether it refers to individual cases or whether this is a broad brush approach. Well, I think the registrar will specify a date in the letter. And then in the subsidiary legislation, there should be a time frame provided. We cannot just allow pending applications to stay here indefinitely. So, say in the registrar's letter, it may say a response within 2 weeks. Ms. Maggie Chan. Thank you, Chairman. I think there should be a consistency in the subsidiary legislation. It should expressly provide a time frame. There should not be any discretion for extension of this time frame, because if there is any difference in the approach currently adopted by the legal profession, we should be informed as quickly as possible. For pending registrations, we are given a slip or a note. But if it depends on your dialogue with the land registrar, then there is a lack of legal basis as a general rule. So you should explain to the legal sector as quickly as possible. Mr. Lee, page 34 of the marked up copy. Clause 17. The new Section 17 will replace the old one, removal of obsolete entries. The registrar may exercise a power to remove obsolete entries and also do so on application by any person to provide flexibility. Mr. Tony Che. Right here, it refers to removal of entries, but not amending entries. Well, we have subsequent provisions referring to amendments. Here, it refers to a legal charge. When it is discharged, then the entry can be removed. Well, in short, this provision is about removal of obsolete entries, and there is also another provision to amend entries. Yes, only when an error has been identified. We'll come to that later. Dr. Wendy Hong. Apart from removing entries, can we withdraw the entries? After making an application, can we apply for removing the entry? Well, we do not have this withdrawal mechanism. Due to lapse of time, this entry may be removed from the title record, but the documents should also be remain. The documents should still be available for inspection. So let's say I submitted an application and then I would like to withdraw it. Is it the same as removing or removal of the entries? Well, removal means removal of something that has been registered, but you're just referring to applying for registration and then withdrawing the application. Is that right? I think before the matter is successfully registered, you may apply for withdrawal of the application. Mr. Paul Chair, about 17.3, can you give us some examples why there is a chance that this entry may be, the application for removal may be refused? For example, in the case of a consent caution, the property owner or other relevant persons may apply for it to be removed or deleted, but will consider whether the consent caution is still in force if there is no proof that it is not binding. We may refuse the application. Mr. Ambrose Lam. Now, for pending registration under the current system, and I'm not talking about the new system because I don't think there is it is likely to happen. For the old system, as a practicing solicitor, it takes years for you to go through everything. And then there might be this entry in the register. You need to be careful. So about pending registration, I think the system works, but there should be a time frame because 17 refers to entries already put on the register, and then the registrar may have correspondence with the applicant. They come with good reason. They are not totally vexatious. But what happens if you refuse to respond? Is it possible to remove the entries?
Mr. Lee, thank you. We are actually asking the applicant questions even when the application is pending. When he or she couldn't answer our questions, we will then reject the application. In the past, there wasn't any legal basis upon which we could remove the entry or the application. Well, your question is in relation to A to D Roman numeral 5. Next, Mr. Louis Lung. Thank you. I'd like to ask about section 17, brackets 2, brackets B. The registrar may exercise the power under subsection 1 and B on the registrar's own initiative. Can you give us an example? Under what circumstances may the registrar exercise this power, that is, to exercise the power of removal? The example I gave you just now is that when a mortgage has been discharged, then the registrar may remove the said entry. Mr. Lung, does it mean the administration will, on a regular basis, conduct reviews? I believe there is a vetting procedure by which you make your decision to remove certain entries. I'd like to know whether there is such a procedure. Well, I don't believe we have a regular vetting procedure, but when we receive applications, we will handle all these together. That is, in relation to the charge and the application, we'll remove them all together. Any follow-up, Mr. Lung? When there's an application for a discharge, then the registrar may not be exercising the power on his or her own initiative. Does it mean, based on my understanding, on the registrar's own initiative, under a particular circumstance when the registrar finds that he or she needs to take the initiative, there are certain situations or circumstances leading to the decision of the registrar. So I'd like to know what real-life examples you can give me. In other words, what would prompt the registrar to exercise this power? Do you understand Mr. Louis Lung's point? Yes, I do. One is not making an application to delete the entry. When we receive an application, that is when we notice that a charge has been discharged, after registration, we will remove them all together at the same time. Mr. Lung, apart from this situation, any more example? Under what circumstances may the registrar exercise their power on his or her own initiative? Well, when the buildings department has issued an order and when the order of compliance, when the order has been complied with, then this is an example. Mr. Porte, thank you. Do you mean you want to reduce the workload of the registrar? In other words, you want to have regard to the existing situation. Can you clarify your policy intent? For the title register, we wanted to show valid entries or entries that are still effective. Just now, Mr. Lee answered the question in relation to Section 17, bracket 3. I'd like to know, apart from the scenario you just now mentioned, can you cite any other provisions under this ordinance? Mr. Lee, just now I made reference to consent caution. Section 17, bracket 3. An application for the registration of the removal of an entry is to be refused if the removal of the entry is provided for in any other provision of this ordinance. So I'd like to know whether you could cite any other provision under this ordinance. Mr. Lee?
喺
73 is about consent caution. It's about the withdrawal or the deletion of the consent caution. When someone is making an application to withdraw the consent caution, one will have to submit evidence to prove that the consent caution is null and void, and it should be withdrawn. When one fails to submit such evidence, then we will reject his or her application. In addition to Section 73, what else? Well, Section 73A, similar provisions as well. Mainly these two sections, is that right? Well, I just want to seek clarifications in relation to other provisions. So I'd like to know whether there are any other provisions in addition to Section 73. If you cannot give me an answer right now, you could supplement the information later on. Let's look at Section 82A. Section 80. There are a few other provisions about this aspect. That is about the withdrawal of the consent caution. There are similar provisions. Mr. Ambrose Lam. I'm talking about the entries under Section 8 and Section 17. The registrar may remove such entries pending registration. In the past, there wasn't a legal basis upon which the registrar could exercise the power. In other words, for matters not under the future amended ordinance, the old mechanism will still be invoked. Is that correct? Yes. Ms. Mackie Chan? Thank you. I'd like to follow up on the question asked just now. In relation to obsolete entries, what about in a new building? When developers need to file plans, DMC, or in the case of any oath, when there is consent to assign, that is when the sale and purchase agreement is to be signed. Afterwards, there will be a document signed. In the past, there were other procedures. So will these procedures not be applicable in the future? Well, our current design is that what happened in the past will still be on the register. They won't be removed from the register. That is for the perusal of other people who would like to check the relevant register. We'll give you an example later on in relation to what will be retained in the title register. Thank you. Marked up copy, page 35, section 18, clause 18 amending section 18. There are no changes to the provisions. These are just textual amendments. Now on to the next clause, page 36 of the marked up copy, where Mr. Michael Lee. I'd like to go back to page 35. Under boundaries, there are the words in brackets not yet in operation. Do these words need to be struck out, Mr. Lee? Well, there are words in brackets not yet in operation. And that is the usual mechanism in place in relation to existing legislation. Legal advisor, well, the ordinance hasn't yet come into operation. It hasn't yet taken full effect. It will only come into effect when there is a commencement date. That's why you can see the words in brackets not yet in operation. Let's see if the DOJ has anything else to add. DOJ? Thank you, Chairman. For this marked up copy, it is the version on Hong Kong e-legislation. For easy reading by readers, there are notes added for readers to have a better understanding of the ordinance. For example, not yet in operation are the notes for readers. They aren't embedded into the legislation itself. So when it comes into effect, we will remove these words in brackets, in other words, not yet in operation. Clear enough, Mr. Michael Lee? Thank you, Chairman. We are discussing this ordinance, and basically it hasn't yet come into force. Why do we still need to put these words in brackets, not yet in operation? Well, this is available on Hong Kong e-legislation website. That's why we have put these words in brackets not yet in operation. When this ordinance has come into effect, these words will be removed. We are right now going through clause by clause scrutiny. Why do we still need these words? Well, we haven't yet passed this ordinance. That's why you can still see these words. Thank you. Mr. Lee, please continue. Moving on to page 36 of the marked up copy. Clauses 19 and 20 amend section 19 and add section 19A. Let's pause. Mr. Andrew Lam and Mr. Benson Look, do you want to ask questions about section 19? Yes, thank you. Section 19 brackets 2 and section 19A brackets 2. Subsection 1 applies irrespective of whether any of the lots concerned is held under a register, a long-term lease. I'd like to confirm this. I'd like to confirm my understanding of registered long-term lease. Does the long-term lease need to be registered first, irrespective of whether any of the lots concerned is held under a registered long-term lease? So it means a short-term lease may also apply. The ordinance targets new grant, including long-term lease, so the focus is on registered long-term lease. Mr. Lee, well, it covers registered land, for a lot held under registered long-term lease, it will be covered as well. So whether it is registered or not, it will be covered as well. That's the case according to the policy intent. Is that correct?
Well, Chairman, I think it should be the latter, because for combination, we're talking about combination of registered land. So it's either registered land or registered long-term lease. These two can be combined. Registered land, new land, in other words, or registered long-term lease. They can be combined, yes, and this provision applies. Mr. Benson, look. My question is this: 19.1, the registrar may, if considered appropriate, on application, combine so and so. On what basis will the registrar consider the matter to be appropriate? Let's say if there are terms that are entirely different for two pieces of land, such as different periods of tenancy or lease, will there be issues? Or if considered not appropriate to be combined, would there be an explanation for the applicants, Mr. Lee? Well, usually we say if there is development straddling two pieces of land and that individual flats may be sold in the future, we consider whether the same owner holds the two pieces of land in the same capacity. Say if AB is a joint tenant or AB is a tenancy in common, then these two cannot be combined. Only when the status of ownership is the same will we allow combination. Registrar. If we take a look at 19.3, the combination of individual title registers does not by itself operate to authorize the amalgamation or unification of government lease of the lot concerned. So the period is not something that we consider in combining title registers. Dr. Wendy Hong, do you have a question? So after combining two registers, if the expiry date of two pieces of land are different, then does it mean that they will remain status quo after combination? Yes. Next, Ms. Maggie Chan. Right, this is a provision on combination. So if I check the title register, what will I see? Do I see the combination of title registers? Is it possible for me to trace what happened before the combination? The answer is yes. The current practice will be adopted. Even after combining two lots, you're still able to check the register of the old lot. Please continue. 19A. New section. It amends subsections 3 and 4 of section 19 about individual title registers. We've deleted the requirement that the person must be the owner of the undivided shares. Pause here. Mr. Tony Chair. Yes, in the original ordinance, Section 44 refers to the division of land, and that the boundary should be verified and signed by the land survey or property surveyor. Is it still necessary? Now we focus on only the title register, individual title registers and the division, but not the land boundaries. Say in the future we have two lots, and then each will have their individual title registers, and then we can combine the individual title registers. For removal or deletion in Section 44. We will come to that in a moment. This requirement is put in place because of the corresponding land surveillance ordinance. Mr. Louis Long. Chairman, I have a question on a general policy issue. Since many members have asked questions on register inspection. So supposing upon commencement of this ordinance, when we move to title registration system, we're still able to inspect registers as what we have been doing at the moment. Mr. Lee, in essence, the answer is yes, but I'll come to that in greater detail later. Please continue. 19B. It sets out that the registrar may approve an application for the allocation or reallocation of any undivided shares in registered land. If there are no questions, I move on to Part 4. Legal advisor. It's a point of drafting. 19B1. Reallocation and then in bracket or provisional allocation or reallocation. Do we need another word provisional in front of allocation, reallocation, or do you think that this current drafting is sufficient? Now, the legal advisor's point is correct. If we do not add the word provisional, it could be read as not provisional allocation or reallocation. But we'll come to a later provision as we understand. There will be an opportunity to clarify provisional allocation and reallocation, and that there is no need to put the word provisional in front of reallocation. Please go on. Part 4. Registration of title to land and connected matters. And also about registration or date of first registration of new land. Page 38 of the markup copy. Section 21 will be repealed. About the definition of LRO land, new land, short-term tenancy, these terms have been moved to the interpretation clause in Part 1. So Section 20 will be removed. Page 39. Clause 22 amends Section 21, amending registration of title to new land. It's a textual amendment with no substantive change in the meaning. The Law Society put a question about the date of registration of new land. So the same answer applies as in Section 15A. The date of application will be the date of registration. And then page 40 of the marked up copy, clause 23 repeals Section 24 registration of LRO land. Because of the implementation of the new system, this old provision will be repealed. The next part relates to effect of registration and connected matters. Page 41. Clause 24 amends Section 25 and 26 about effect of registration of transfer of registered land as well as registration of long-term lease. A purchaser with value consideration will get the rights, an legal estate, or equitable interest free from all interests and claims. Section 25 refers to registered land and undivided shares. Section 26 refers to long-term lease and the undivided shares. Page 45. Clause 25 amends Section 27. For those acquiring registrable interests without value consideration, the interest will be bound by a number of things. Next, page 46, overriding interests. Clause 26 amends Section 28 about overriding interests. A number of amendments, including 28(1)(c) Roman numeral 1 about rights or easements this will be repealed, and then 28(h) about the charge under the Estate Duty Ordinance. The Estate Duty Ordinance has been repealed, so this provision will be repealed correspondingly. 28K, this is a new section because of the new land and no adverse possession under the new land first approach. This will be repealed. The next one is 28(1)(m), which is a new subsection. The rest is textual amendment. Next, page 51, adding section 28A. It refers to the purchases for valuable consideration and the right not being affected by notice. So the doctrine of notice will be repealed or removed to protect purchases for valuable consideration, and so as to provide certainty for purchases for valuable consideration. Part 6. Certificates, searches, evidence. It relates to evidence that may be admissible for the checking of register. Page 52, clause 50. Section 29 replaces the old one in relation to the issue of title certificates. In light of the requests from stakeholders such as Law Society and Estate Agents Authority, Section 29 will be amended. The registrar will issue a title certificate to a title owner. A title certificate contains the following matters. We should now refer to the PowerPoint slide. The certificate will come with a serial number. Date, time, QR code, NFC, to verify the authenticity and validity of the certificate. It also contains title number, lot number, as well as other matters such as any liability and the particulars of the owner.
Page 53 of the marked up copy, we have added sections 29A and B. 29A, title certificates admissible as evidence. There are textual amendments without substantive change to the meaning. Section 29A amends and improves the original Section 29. When one couldn't submit the title certificate, one will have to provide an explanation. Thank you. Dr. Wendy Hong, can you explain the differences between cancellation and removal as we touched upon it just now? You refer to withdrawal, whereas right now you are talking about cancellation. Are there any differences? For withdrawal, it refers to the matters having been registered, whereas for cancellation, it's about title certificates, and the title certificate is issued by us. That's different. But when one registers a matter, one also has a title certificate. Is that correct? Well, there are a lot of items under a title certificate, say encumbrances and so on. But when that is completed, then the entries may be struck out or they could be removed. It's about the cancellation of a title certificate. Mr. Lee, is that right? Yes. Is that clear? So this has to do with the entire title certificate, whereas for withdrawal, we were talking about the details in title certificate. Is that correct, Registrar? Well, a title certificate is a piece of paper, as we mentioned earlier on, when one has to apply to change the landowner to another, then it will have to change the title certificate. A title certificate is not part of a title register. It's just a record in the title register. Thank you. Moving on to page 54 of the marked up copy. Clause 30 adds a new section 30. Public inspection of registers and documents. We have prepared a PowerPoint slide on this. Let me take you through this slide. So what can be checked? In the system, one can conduct a land search. One can check the registered instruments. One can also apply for copies of the registered instruments. These could be obtained through a land search. In the new system, what can be checked is similar. Let's see the first box. Entries of the title register. In the future, there are matters in the title register instead of registered instruments under the register. At present, we can get the copies of the registered instruments, but then in the future, one will be able to get the supporting instruments such as memorials. And the difference lies in the fact that you can see there are two boxes. One, supporting existing entries and supporting entries in the past. One only needs to refer to existing entries when they need to check the entry in the register. They don't have to refer to past entries. As in the entry, there are personal particulars. So there are two categories. One category is the information that can be accessed by the public, whereas for the other category, that is the entries in the past, only specified personnel may check such information. Some examples include lawyers and banks. These couldn't be accessed by the public.
咁條
What could be checked or what could be inspected? Well, excuse me, hang on. Miss Maggie Chan has pressed a button. Miss Maggie Chan, please. For specified personnel, say lawyers and banks and so on. The administration just now said and so on. So, whom do you refer to when you say specified personnel? It means there is a scope when you specify some persons. These will be set out in subsidiary legislation later on. Well, can you tell us right now what kind of persons will be covered? Lawyers, accountants, banks, surveyors, public officers, property management personnel, and so on. Real estate agents as well. Ms. Maggie Chan, thank you, Chairman. Why is the scope so narrow? Why does it have to be so narrow? Supposing I'm a potential buyer and when I have to place a deposit, I want to check the titles, but I want to save money and I don't want to engage a lawyer. Why must I engage a lawyer, and why must the scope be so narrow? Registrar, thank you. The design of the system is based on one need. You can see three main categories of information. For the first two categories of information, they could be inspected by the public. Say for existing entries of the title register, in other words, the owners of the properties, or the previous owners or the previous landlords of the properties. For the second category, as you can see in the second box, they are the supporting instruments of existing entries. These can be accessed by the public. We consider these pieces of information are sufficient for potential buyers of a property. For the box at the bottom, they could only be inspected by specified personnel. They aren't just about past entries. It's about the supporting instruments and application forms supporting the past entries. In general conveyancing or transactions, one doesn't have to inspect such detailed documents. Just now we talked about removing obsolete entries to the back. When some matters have become obsolete, these do not have to be inspected owing to policy concerns. However, for professionals, when they need to discharge professional duties, they may have to refer to these documents. Say for an accountant may have to conduct due diligence and they may have to check these documents in the past. When a lawyer needs to work on legal proceedings, a lawyer may have to check these documents. Then they may have to inspect such documents. For property management companies, the personnel may have to check whether the landlord is still in debt, and they may check such record. So we adopt a needs-based mechanism, in other words. Ms. Maggie Chan, thank you, Chairman. What if one impersonates as a specified person? Say one says he or she is a property agent, but then when that person has already lost the license, are there any penalties when one still makes an application impersonating a property agent? Mr. Lee, in subsequent sections we'll come to the penalties part. This is a case of fraud, and there is criminal liability. That is one makes an application in the case of a fraud. Bogus instruments, bogus documents, false instruments. Under this ordinance, when one impersonates a specified person, any penalties? Well, in general, this is a case of fraud making an application. Well, Ms. Maggie Chan's question is that under new land, in the context of indemnity, you may have additional penalties. So Ms. Maggie Chan's question is that when there are additional penalties in relation to indemnity, as for this provision in particular, are there any additional penalties in this regard? Section 98(3).
Part 2.
即係一個人
A person who knowingly or recklessly makes any statement or furnishes any information that is false or misleading in a material, particularly in connection with an application, this constitutes a criminal offense.
明白。
98條
Please refer to Section 98(3). Well, simply put, the member asked about any additional penalty. The answer is yes, right? Next member, Mr. Polte. Well, probably put it this way. As for specified personnel, the scope is actually quite wide. When one needs to seek assistance, whether one pays or not, one may seek assistance from a lawyer or from a legislator. Of course, I do understand for vehicle registration, the scope has been narrowed. As we understand, there are cases not only specified personnel may make an application for inspection of the records. So you want to follow the mechanism in relation to vehicle registration, right? You want to strike a balance. Or, as Ms. Maggie Chan said, do you want to provide for a catch-up provision? As long as the registrar considers reasonable, you may accept such an application. Is that correct? Which is the direction you want to pursue? Mr. Lee or registrar? Registrar, thank you. Thank you, member, for your question. We indeed have taken into account what you had just now said. When one wants to refer to entries in the past, however, when one is not a specified person, is there any avenue for these persons to make such an application? As for detailed search arrangements, we provide for the relevant provisions in subsidiary legislation, and we are indeed considering this. There are many AI search engines, and buyer may not want to engage a lawyer, an accountant in particular, without infringing personal privacy. Is it possible to cover a wider scope in subsidiary legislation? P.S. Ms. Doris Ho, thank you. I'd like to talk about our policy intent in relation to land search. First of all, we understand what Mr. Polte said. In relation to vehicle registration, there is a register, and there is yet another register for companies' registration. This land register or title register is special in the sense that there are active property transactions in Hong Kong. So we need to keep the system transparent. Just now in the course of discussion, when it comes to property transactions, one may easily access our website, and one will inspect the record and find the information he or she needs. At the same time, we do believe we need to respect personal privacy as well. So we want to keep the system transparent, but we don't want the inspection to affect the operation of the market either. That's why we have already struck a balance. That's exactly how we have come up with the PowerPoint slide we just now showed you. When one wants to buy a property, you may access our website and you can easily check the landlord of the property. You can also check when the property was bought, as well as the cost at which the property owner acquired the property. One may also check the number of landlords beforehand, as well as the date of the transfer in the ownership of the property. This could be accessed and inspected by the potential buyer. As for supporting instruments behind these property transactions, how much could the public inspect such records? As for existing landlords, some instruments could be inspected by the public. However, when it comes to past entries, we need to tread cautiously. For past entries, they concern personal privacy, such as the address, identity card number of the previous owner, as well as the signature of the previous owner. These are pieces of information about past instruments. We think it is only appropriate for specified persons to inspect such records. That's exactly how we could strike a balance when we put in place this restriction, and that highlights the special feature of a title register. We want to implement policies that can safeguard personal privacy. Thank you.
Mr. Andrew Lam. Mr. Tony Chair, did you also raise your hand? Right. Very briefly, I think the PS already explained the matter. We need to level with the public the policy consideration behind. Mr. Andrew Lam. Well, I had the same question as Mr. Tony Chairs. The administration already gave a reply. We have a 3-hour meeting today, and as mentioned just now, we will take a 5-minute break and then we will come back from here. So let's come back at 11:08.